Good evening.
Good evening.
You are here with Courtside with Lawman,
And Carmen B.
and we are here to talk about criminal law and issues that affect the criminal justice process, as well as other issues that affect the public.
Yes. And we like to say that if we answer questions or anything like that, make comments that it has not created an attorney client relationship with me, Lawman, or Carmen B. But we do want you to bring those questions to us either through the chat or through the phone number, which is.
And the phone number is 916-384-8204. Again, 916-384-8204.
Okay. Now, picking it up from last week, we were talking about the court system if you ever find yourself having to deal with a criminal case. So we stopped at right before jury trial. I think it was preliminary hearing, correct?
I believe so.
All right.
We may have gotten slightly past that, but I'm sure a recap won't hurt.
So let's recap at least a bit what happens at the end of a preliminary hearing and the purpose of a preliminary hearing. So I'll go with purpose. A preliminary hearing has to be had when it's a felony charge. No matter what kind of felony, you're entitled to a preliminary hearing. And at that hearing, the judge really wants to have to determine just two things. Number one, they have the right person charged. And number two, that a crime has been described. So they call that probable cause, meaning I have a strong suspicion that a crime occurred and that's the person who did it.
And that's the burden of proof at preliminary hearings. So it is not as high as the burden at jury trial.
In fact, it's low.
It is a very low burden.
Preponderance.
The court is basically answering two questions. Did a crime probably occur? Was the accused person probably the person who committed the crime?
And they're not looking to judge the credibility of witnesses necessarily, whether you have a defense to the case. You see, and the best tactic as a defense lawyer is not to be ready to present your entire defense at a preliminary hearing unless you know it's going to move the judge.
And that's because the odds are not in your favor. And it's not that the judge is not assessing credibility. So I disagree with you there. I think the judge is assessing credibility, but it's at such a very low level. So it's almost as long as someone comes in and says that there was some action committed that constitutes a crime and someone else or some evidence that leads them to suspect that you were that person, the judge is going to do what's called hold you to answer to the charged offenses.
Now, what I mean by credibility there is that they are not listening to witnesses and determining who is telling the truth. If there's a dispute in the facts, then they're likely you're going to be held over for trial.
And also, what you must understand is at the preliminary hearing, they usually, if it is a crime that involves actual victims, those victims usually will not be testifying because hearsay is admissible at the preliminary hearing. What that means is the officer who investigated the crime can testify about what witnesses or the victim stated to him or her about what happened. The officer can also testify about what other officers told him their actions were during the course of the investigation.
Correct. And they allow that one level of hearsay in, but not two or three. So your attorney has to be ready to object to something beyond a first level of hearsay.
Well, actually, multiple levels of hearsay are admissible as long as there is an exception to the hearsay rule for each level of hearsay.
And I didn't want to get into an evidence class. However, Carmen wants to do that. So, but what she's saying is, look, if you have a reason for hearsay, pretty much an exception or a non-hearsay usage, then the evidence can come in. And that would be an independent reason for that level. But the next level would have to have its own independent level of hearsay.
So, for example, the officer can testify about what Bob told him, but he could not testify about what Bob told him about what Tracy said about what she saw transpire.
Right.
Unless there is a hearsay exception that fits from Tracy to Bob.
Right. So this preliminary hearing, well, let's see. The first thing that you're going to know is that your attorney will tell you that you're in a particular department, and it won't be the department that you've been in before. So whenever your matter is set for preliminary hearing, it'll probably be set for what's called Department 9 downtown. Now that's a jump off point only. From there, it can get assigned to, let's say, Department 28. And then what happens is your lawyer and you will arrive, the DA will arrive, the bailiff will be there. There won't be any audience members generally, unless you brought them, or the DA, they're coming with the DA, but generally no audience members at the preliminary hearing. And the first thing that's going to happen is that the lawyers usually will have a discussion with the judge about what is the case about, because believe it or not, in the court file at that time, there is hardly anything except a complaint that reflects what happened in this particular case. There's no police reports or anything like that. So the judge has no idea what is being brought to them.
And Sacramento County actually does it slightly different than some of the other counties. Some other counties, at your arraignment, the preliminary hearing date is immediately set. In Sacramento County, there is a little bit more leeway in terms of discussion and negotiation and the providing of discovery before the setting of a preliminary hearing date.
Now, what she's saying is right. However, if your case needs investigation or something like that, then your lawyer should not be setting a preliminary hearing right away.
Now, and again, in some other counties, and you know this, they force you to set a preliminary hearing. You show up at the arraignment and you have no option. Now, they will perhaps let you set the date further out.
Waive time.
But they will. There are counties that will make you set the preliminary hearing at that very first court appearance.
And what waiver of time means is this. You want me to set a preliminary hearing? Well, I have a right to have it set within 10 court days or 60 calendar days.
Pre-pandemic.
But what you want to do in 10 court days, it's hardly possible to get your investigation done, to understand what evidence you don't have. A lot of times a case may turn on a video, and that video may not be acquired right away. So you have to get it. A preliminary hearing is a perfect place where something like that should be shown. So you would waive time in that I don't want my preliminary hearing set in 10 days. I'm willing to waive that time and set it in 30 days, 40 days, 60 days, whatever it takes. And if it goes over 60 calendar days, I'll waive time to go even further. Most of the time, serious matters, homicide, shooting cases, things like that, severe injury matters will not be done within 60 days. One of the problems is you won't have a coroner's report usually for about 6 months. You won't have toxicology reports, investigators. What if you need an accident? Reconstructionists. They're not going to get that work done within 60 calendar days. So your attorney has to use their own wits and smarts to go, wait a minute, it would hurt my client to rush into this preliminary hearing and have a trial set right away. So we would waive time to give me time to investigate and find things that I need in order to defend my client. So, but a preliminary hearing is important strategically, okay? Because here's what can happen. A case can come on as a felony and leave as a misdemeanor. A preliminary hearing is an excellent spot to do what's called a 17B motion. Drop it to a misdemeanor if it can be, Judge.
And again, a reminder, not all cases can be reduced to a misdemeanor, but there are a substantial number of offenses that can be charged as misdemeanors or felonies.
What do we call those things?
We call those wobblers.
Why?
Because they can be either a felony or a misdemeanor.
They kind of wobble back and forth. Now, not only that is a good strategy, moving your case to a misdemeanor, but a preliminary hearing is a wonderful opportunity to test the prosecution's evidence. Meaning, you're going to have officers who come in and testify, and they will testify what another person said just based on what is in the police report. The officers cannot read the police report. They can only refer to it to refresh their recollection. So they don't usually memorize all the facts in the police report, and they will be glad to refresh their recollection to hear facts that they should testify to. But what a preliminary hearing gives you a chance to do is to ask questions to lock in witnesses to what they have said or what they didn't say, to what they did or what they didn't do. So if an issue is over whether a person did something, went right, you can nail it down so that later on the person can't change their mind. Or if they do, you have what's called impeachment evidence that you can present at trial. So a preliminary hearing, evidentiary-wise, could be very, very useful. And one thing I learned a long time ago is you don't waive your preliminary hearing unless you get something in return. Quid pro quo. Give me something if I waive my hearing. And really, there's no reason to waive a preliminary hearing. I mean, you can literally sit there and not ask any questions.
Now, I'm going to disagree with that because there are certain instances where a waiver, if you get this agreement, is going to be beneficial to you.
Right.
And that would be where your client can be charged with additional crimes. But if, as part of the waiver, the district attorney agrees that they are not going to file any additional charges, because there you are protecting your client's potential liability for other crimes that could subject them to greater punishment.
True. Now, that'd be one reason to do it, definitely. But you're getting something in return. So you don't ever waive a preliminary hearing just because your lawyer is lazy, okay? If they ask you and come to you and say, hey, we should just waive this preliminary hearing, it won't mean anything. You should be very skeptical about that, because there's always something to gain at a preliminary hearing. You get an opportunity to ask questions of the officer regarding what they're saying someone else said. And the key is locking that in at a preliminary hearing because it's under oath. All witnesses are sworn in, and there will be a transcript of that preliminary hearing. And there are other reasons why, in case you want to try to settle your case at some point, in time and stuff. So it's good that at a preliminary hearing, sometimes you can approach the judge after it, and the judge would either say, hey, you guys really need to settle this case. And, the judge can give you some sort of enlightenment on how strong a case could be or not. So after a preliminary hearing, the magical word is holding over. They call it a holding order. And that just means that this matter is going to trial. Now, what if I had misdemeanors only? What if I only had misdemeanors, Carm? Do I get a preliminary hearing?
You do not.
What if I got some felonies and some misdemeanors?
You get a preliminary hearing on the felony, although some details that relate to the misdemeanor may come out during the course of that hearing.
Yes. So see, there's always something to gain. Sometimes you can even get cases dismissed at preliminary hearing when it's an ID issue and they can't identify your client.
I would say that that's fairly rare.
I've done it.
Remember, I'm not saying it's impossible. I'm saying it is fairly rare that will happen. And we just don't want the public thinking, oh, well, then at preliminary hearing, the charges against will be dismissed because lawman said that has to happen. Because they can bring out, someone may not be able to identify you, but there may be other evidence that still points to you. That evidence may still be wrong. but it still might point to you, and that could be you. So we don't want to mislead you into believing that because one witness can't identify you or because their identification is shaky, that the court is not going to hold you to answer. You've heard the saying that you can indict a ham sandwich. The preliminary hearing is kind of that same thing. And I specifically remember one case in particular where my client had been a good Samaritan, actually helping someone who had been attacked. But the victim was so out of it from the beating that he had suffered, when he came to and saw my client's face, he believed that my client was the person who had attacked him. He was wrong. There were 5 defense witnesses who were not friends of my client, but who could attest to the fact that he had been someone who was not involved, that he actually was the Good Samaritan, had been inside of the establishment, ran out to help the victim, also came back to get ice and towels for the victim. And even in that circumstance, with having the officers testify about what the other witnesses had told him, because the victim had identified my client was still held to answer. Now, the judge in that case did say, this is a very weak case, and I don't understand why the district attorney's office is still proceeding. But they continued to proceed, and we actually had to select trial dates. But approximately, I want to say it was a week or 2 after that, the district attorney's office did contact me and indicate that they were going to dismiss the case.
So at least justice prevailed there, but a little late, as we would say.
Yes.
Now, after that preliminary hearing, a holding order may issue or not issue. And one last thing on the evidence thing, Carm. You know, we've heard the term circumstantial evidence all the time. Everybody always talks about circumstantial evidence. Now, when I was talking about ID, there have been cases where the actual victim is called to a preliminary hearing and they cannot pick the person out. And that's the situation I'm talking about. But most of the time, it's going to be circumstantial evidence that actually will dictate whether a person is ID'd. So I'm going to start a little bit about what that is. For example, if the description of a person is 6 foot, black guy, bald head, glasses with a little tin in them or something, and he had on blue tie and a light blue shirt, and he did something to me, okay, that person. Now, they find me 3 blocks away and I'm walking down the street. And the cop would what? Probably stop me. And I'd, of course, say, am I free to leave? And he'd say, no. And I'd say, well, then I want my lawyer. And then I would proceed through the system. And at that preliminary hearing, a witness would come in and say, what was the description of the individual? They would give that description. And the officers, if they're smart, they'd take a picture of me or take the booking photo of me at that time, and I could match that description. Now, there could be wrong. It could be wrong, be another guy walking down the street, but that circumstantial evidence is what would allow a judge to hold a person over. So now you're looking for your alibi defense. So just by your clothing, by a car, you can be identified. So we're held over and we're going to get trial dates set. Now, once again, time comes into play. If you want a speedy trial, we have to set that trial within 60 court days if it's a felony. So if you want to waive time.
Pre-pandemic, it was 60 days.
Yes. Now it's 60 plus 30, something like that. You get a 30-day lead on there at the end. But if I want to waive time, I may set it for 180 days. However much time I may need. But realize now your case is set for the ultimate action in the criminal justice system, which is a jury trial. Putting people in a box, random, picking them, selecting them, deciding that they're going to hear the facts of the case.
When you say putting people in a box, just so that there's no confusion, you're referencing the jury box.
Of course I am. Well, how else would people be boxed in? All right. So a jury trial is depicted in television all the time. I mean, that's what makes all the television shows really, really good and exciting, is the jury trial, because that's where the action is. But most of a trial is kind of boring, unless you're questioning the witnesses or doing your opening and closing.
And not boring to us, but boring to someone who may have to sit and watch, and someone that we want to pay attention to all of the evidence that is coming in.
Correct. Now, I'm associating television now because most people get what they learn about trials on TV. Yep.
We do have a comment in the chat. It's Sean. There certain types of evidence that can't be used in court.
Exactly. We call it inadmissible evidence. So that can be evidence that you may have something that seems to be good, right? An ID process, something like that. An item, an object, someone's words that they say, like hearsay.
The very first thing is that the evidence must have some relevance to the issues at hand.
What does that mean, though, Carm? What is relevant evidence?
It means it has to be related. It has to assist in establishing or not establishing a particular fact.
And that particular fact would be an element of the cause of action, right?
It could be that, but evidence also could be related to a witness's credibility.
It could. And how about evidence related to where a person is, a time or something like that, So, your receipt that you get, it's relevant because it'll show where I'm at a particular time.
So, for example, Sean asked about, a voice recording. And yes, audio recordings can be admitted if they can be shown to be, number one, reliable,
right,
and that they are what they purport to be.
Right.
So you need a witness in order to establish what is known as the foundation.
And a foundation, just like building a house, means where it came from. How did it start? How do we know this is what we say it is?
So one way of doing that with a recording would be, if it's a recording of a particular witness, to have that witness basically set the foundation in saying that, yes, I hear that is my voice, and I did make that call. Now, again, this is subject to whether or not the statement is hearsay or whether or not it meets an exception to the hearsay rule.
Correct.
We do have another comment from Zimbabwe Walker. Are American citizens actually innocent until proven guilty? Too often, it's like guilty until one proves their innocence, once arrested and charged with a crime. Lawman?
Yeah, this is a television thing, okay? Because it confuses what really happens sometimes with television, because television will show you things that may or may not be relevant evidence and things like that. But the rule is that you are innocent until proven guilty.
That is the rule in theory.
How's it work?
How does it work?
Well, here's how it works. We will tell jurors all the time, we meaning the court, the judge, we will tell jurors, you are not to presume that the person sitting in the chair as a defendant is guilty of anything.
What are you to actually presume?
Well, you're to presume that they are not guilty.
Yes.
Yeah.
And that is what is referred to as the presumption of innocence.
Yes. It is, in fact, it is one of the most protected ideals behind the whole criminal justice system.
It is, but at the same time, it is in theory. We have to look at what happens in reality. In reality, it is very hard for individuals to apply the presumption of innocence. Now, if it is their own son, their own daughter, their own relative that they care about, it is much easier to apply that presumption. And so that is how I like, or if it is themselves, that is how I like to tell jurors to think about it. Apply that presumption of innocence as if you were the person seated in the defendant's chair accused of a crime. And that is really the only way way that I see that humans can actually apply that. Because if you think about it, when we hear that someone has been accused or arrested for a crime, we immediately think, my goodness, why did that person do that, right?
Well,
That's the natural human response. So it actually takes something extra for you to say, wait a minute, this person is innocent, and I'm going to presume they're innocent until there has been evidence, until and if there has been evidence presented to me beyond a reasonable doubt.
Right.
And what is beyond a reasonable doubt?
Ooh,
Lawman?
Well,
Is that might have done it?
Nope.
Is that could have done it?
Nope.
Is that probably did it?
No.
Is that more likely than not did it?
No.
What is it?
It means that you are practically certain. You will go to the grave with a decision of your certainty. You gotta know that that person is guilty, and you gotta know it from the evidence. Because you can walk in and say, "Well, I think they're not guilty," but that would even be a wrong analysis to use because you've heard no evidence. And judges do that all the time. They'll trick people like, okay, so as the defendant is sitting here, and if I told you to vote right now, are they guilty or innocent? What would you do? What would you vote?
Well, they don't really get the our judges saying they're innocent because they shouldn't be. They should be saying, would you vote? Yeah, would you vote guilty or not guilty?
And people say, well, I haven't heard anything yet, so I guess I got to vote not guilty. And everyone will say, yay, you're right. But then there's people who will get up there and they will say, well, you know what? How come a deputy's sitting behind these people? How come we didn't get to see them come through the front door?
And those are all factors that they should not be considering, and the court will advise them of that. The mere fact that someone has been arrested, charged with a crime, brought to trial, or is in custody because they can't afford to pay bail or they don't have a bail is not a factor to be considered at all in determining whether they are guilty or not guilty.
Correct. And it's one of the things that is one of the biggest hurdles that in trial that you do have to overcome. You have got to address that with the jury. If you just believe they're going to believe in the process and that, the presumption of innocence, if you just believe that, you will be highly mistaken. Because I have had almost every trial, somebody comes in and said, well, I think they're guilty. They're sitting there in that chair. A policeman wouldn't have arrested them. They wouldn't have brought them this far if they weren't guilty of something. And sometimes, see, that's the hang part. They may be guilty of something, but not the charges. A lesser charge, a different charge. So you really pump in that presumption of innocence as much as possible to get people to be level-minded, to get out anything one way or the other on how they would presume to vote.
And again, we must admit our justice system certainly is not perfect.
Exactly.
If people were appropriately applying these concepts that we talk about in theory, in reality, our system would work better.
Absolutely. So we are now starting trial, right? All right. This is you want to deal with that first?
Yes.
The juror question? Okay.
Yes. Jurors should take a one-day orientation class of some sort. It's my experience that the public is not informed enough to fulfill this responsibility. Your thoughts?
Oh my goodness. Yes.
I think they receive a small little pamphlet, and I'm not sure that they may get that
a
on
recording
the day,
or something.
on the day of I'm not sure that it's actually sent out with the jury summons.
Right. Right. You get nothing there. I mean, they don't tell you anything.
Yes.
But if you're sitting in the jury room waiting, sometimes they'll play videos or something like that, to try to tell you about your jury experience and things like that. But they stay away from the concepts that happen in trial. Now, what we're talking about, and I see that one day class, because I think that would be important, because
even if it wasn't a full day, because of course people barely want to be inconvenienced by doing their civic duty and sitting as a juror.
Correct.
It certainly wouldn't help if they were to have to spend, a 2-hour class.
Yes.
Just getting some information about the concepts. Again, because a lot of what people know comes from what they watch
on television. Yes, which is usually wrong. Okay.
And again, with the jury selection process, you will hear people say a jury of your peers. That does not mean people who look like you. That does not mean people who are in the same age group as you or in the same generation as you. It just means that they are selected from the community at large in a process that is not discriminatory. And so
where do they come from?
They come from the DMV rolls. They come from the property rolls, which we'll talk about how that can be impacted. They come from voter registration.
Right.
So again, that brings us back to why we say to the public, register to vote. Because if you are not registered to vote, that reduces your chance of being selected as a juror member. And we all should want to do our civic duty in
register
terms of that.
Your cars.
And to make sure that the jury process does contain individuals that are representative of what we look like.
Exactly. And here's something else. A person with a felony can serve on juries now.
Yes, it used to be that they could not. And there was a specific question that asked, and then if they had that, they were excluded. But I think what we have realized, or what our society is realizing, is that there has been a
certain percentage of individuals who have felonies on their record, and they should also be allowed to participate in this part of society. So we've changed that. And then please, if you tell someone from tonight,
we're talking about California,
right?
We can't speak to what the status is in other states. So in other states, they may still be excluding people that have felony convictions. So if you are in another state, that is something that you
got to get your legislator to start changing.
You need to check.
But that's huge because a person who has suffered a felony, even a misdemeanor, and you've gone through the system, you understand a little bit more about what it needs to prove something. You just have a better understanding of what it's like to sit in that chair.
And I don't know necessarily if it's a better understanding, but you have an additional insight. And we want the jury to be diverse. We want people to have differing viewpoints. That is how people can then view evidence differently.
True. I mean, it comes down to the juror of your peers. If I am a felon and I sit in that chair, I would want another felon or a person with a felony to judge me.
Zimbabwe Walker says the grandfather clause, like laws, are slowly being abolished, at least in California, and we hope that other states will follow suit.
One thing that keeps you from serving on a jury, likewise, is a language issue. If it's not your first language and you have trouble understanding terms and terminology, as well as being a peace officer, believe it or not. So we can't have peace officers on the juries.
And why is that?
Well, probably because it would be peace officers are usually working in every single case, and there's somewhat of a conflict there. So that's why. But wives, daughters, sons, uncles, aunts of peace officers are always there. So, which is another issue in the evidentiary area that you have to voir dire on or question on, is how do you treat a peace officer versus a civilian? So,
and you don't treat them any differently.
Right.
Their testimony in terms of assessing their credibility. There's an instruction that lays out different factors that you can consider in determining a witness's credibility, and that same instruction applies to officers that are testifying. Their credibility is not, they're not to be given any additional weight because of the fact that they're a peace officer, because they are human. They can misunderstand what a witness told them. They can make mistakes in their investigation.
Yeah, and they can be biased, straight up.
Yes.
So we're now at a point to where we get sent to trial, right? And we've been talking about juries and jury selection and things like that. And the real of it is this. When you go to trial, you're going to get two lists of potential jurors. You're going to get one that's alphabetical, and then you're going to get one that's called random. Now, the alphabetical one, that's what they're usually going to take roll. So you get there and you get into your courtroom and everything, and they'll start taking roll from the alphabetical. seeing who's here, because you can't start till everyone is accounted for. But then the random is never mentioned, because that's the one you and your lawyer will have. And it's telling you who is sitting in the box and when, meaning it's assigned numbers. So the first 18 to 22 will be called in and put what's called in the box. They'll be up there so that you can see them. And the questioning that goes on is only to that group of individuals.
Now, the other individuals, the other potential jurors are also, they are supposed to be listening to the questions that are being asked so that they can be prepared to answer them or respond to them if they are actually, if they
Called
make
up,
it into
yes.
The box.
The box, as we call it. Why 18
Now,
to 22 people? I only need 12. Why you got 18 to 22 people up there, Carm?
Well, because you're going to have people that have issues. You're going to have people that have vacations. You're going to have people that say that they can't be fair. You're going to have people that say they don't want to sit in judgment of another person. But I don't know if we're going to be able to finish this topic today, or if you want to speed it up a little bit.
No, we're probably not.
Okay.
But it's good to go along a little bit at a time, just so that we can talk about this process. Now, what she's talking about is what's called hardships. The court's going to want to know, do you have a hardship first? And you, as a juror, will be required
Potential
will be required to usually fill out a form explaining what the hardship is. And I'll tell you something. You can't use anything to get off of a jury. You just can't say anything. And in fact, people who try to get off the jury usually get put at the bottom of the list or something like that, and so they're going to sit there all day. But if you have a legitimate hardship, which means I care for someone and they have no other means to be cared for. If in fact I have a prepaid vacation or trip that's for me, not my job, that could be a hardship.
And there are a number of other things that could be hardships as well. You could have a surgery scheduled. You
Right.
could have a doctor's appointment that you have been waiting for 3 months. And if you end up selected on this jury, you're going to miss that doctor's appointment.
Right.
So there are a number of things that can actually represent an actual hardship. What we would prefer is that we realize that it is an inconvenience to sit on a jury, but it is one of your civic duties, and we live in this civilized society. Yes. It's a requirement, and we as a people should not be attempting to get off of jury, out of jury service.
Why?
Because we need people of diverse background in making these decisions. If you're not part of the process, then how can you complain when that process sends one of your loved ones away?
True. And it's true. They'll send up a panel of 40, maybe 50 people.
It's normally 65 to 75, I think.
Well, but they lower it because the peremptory challenges went down and for misdemeanors and things like that, which we'll get to about that. But no matter what, in that group of individuals, you might see 1, 2, maybe 3 Black people in that entire group. And that's all you got.
In my last trial, there was just 1.
And that's all you got. First thing would be, whoa, that's not a jury of my peers.
And a lot of people will say that. And it's like when they say jury of your peers, again, it does not mean people who necessarily look like you. What it really means is a jury from your surrounding community, the city, the area that you reside in.
Those who choose to register a car, register to vote, those are your peers. So, but nevertheless, you're going to get these individuals. We're going to be packed in a room.
And so one last thing, that being said, so if you don't register to vote, you reduce your chances of being able to be on a jury
by 50%. And since it's random, I mean,
And if you don't own property, and that is one reason I think why we see a lesser number of us in the jury pool is because we as a people tend not to be property owners. Not because we don't want to be property owners, but our circumstances and what has happened in our society has prevented a lot of that ownership.
True. Now, we're here. We're going to pick this jury, okay? There's a lot that goes on to picking a jury. You, as a defendant, though, let me tell you, here you want to dress to the T. You want to be dressed up because it shows that I'm serious about what's going on here.
How can I be dressed to a T if I'm in custody, lawman?
Because your lawyer will bring you clothing then to wear.
Will my lawyer bring me good clothing? Will my lawyer bring me clothing that fits me appropriately? Or will I be wearing something that's far too big?
Well, your lawyer can get with your family, and your family can purchase clothing and give it to the lawyer, and the lawyer can bring that up.
My family doesn't have extra money to purchase a suit for me.
Oh, then you might go over to the public defender's office and tell your lawyer to go to the public defender's office and get one of the suits. Know your size, give it to the lawyer, and have them bring clothing.
Now,
You get to have, oh, go ahead.
I was just going to say, one of the things that I've discovered a lot of times, especially with young people, is that they don't actually know their sizes. Now, as a mother,
You can figure it out, right?
and with male friends and the mother of a son, I have been able to figure it out. But I also know, and I have seen other defendants, not my clients, whose attorneys have not taken that time to realize, wait a minute, this young person doesn't actually know what size dress shirt that they wear.
Right. You'd be amazed, but it's truly true.
Yes.
You know, they don't understand that on a dress shirt, there's a neck size, an arm length, you know, and a chest size that you got to take into consideration.
And on pants, it's not just small, medium, and large.
Right.
There is a waist size. There's an inseam.
Yeah. And you don't want them baggy, you know. You want to wear or bring dark socks because you can change shoes in the courtroom. Always have slip-ons. They're far easier to slip on and off, and you hide the old shoes.
And that's if you're in custody. Of course, if you're out of custody, just dress your absolute best.
Right.
If you don't have a suit, still a very nice dress shirt and a tie does the trick. And what you need to remember, right? When you're with your friends, you can dress however you want to dress. But now you're appearing before people who are going to make a decision about your life that may be a life-changing decision. You want to put your best foot forward.
Right. And it goes the same way for females. You know, don't come in like you just got out the club and stuff. You know, you got to be wary of things that are way too tight, you know. And Carm can tell you. I mean, you got to be wary of nails that are, you know.
You don't want stuff that is too revealing. Yeah. Again, you may say, oh, Miss Butler, these people shouldn't be judging me. But they are going to be judging
That's
you.
Right.
And so you want to present just a very good image
right.
with anything that you do, right? When you go on a job interview, you want to put your best foot forward.
Right.
And that's all that we're saying. We're not criticizing how you dress in your normal day-to-day interactions, but when you're appearing before people and a judge who is going to make a decision, again, life-changing decision about you, you want to put your best foot forward.
Now, what if I got dreads?
I'm going to let you answer that as a man who used to have dreads.
Oh, whoa, all right. And she's right. When I passed the bar, I started growing dreads. And they became down to my shoulder, and I cut the sides and let it bald. So if your hairstyle is something that's unique or different, I wouldn't worry about that. I wouldn't change you. I think you got to be natural in terms of feeling comfortable when you're sitting in that room. And you see, she's going to disagree with me, but I'm going to get this part out. Look, if in fact you grow your dreads, what I would say is you tie them together and pull them back so that they're not too wild over your face. You don't want to cover your face because you want people to see you and you see them. Now, she was talking about the dress shirt and tie. You know what I always ask? I always ask, have you ever worn a suit? Have you ever worn a suit and a tie in your life? A lot of people say no. And you know what will happen is they'll be uncomfortable in this new clothing. So that's where a sweater might be good. You know, something else shirt-wise that does not necessarily a tie, only because I want you comfortable, because you'll be sitting there 6 hours a day.
If you're with me, you're going to be comfortable in a suit and tie. We're going to work on that. You will be comfortable. But Lawman and I kind of disagree on the issue of your hair, and I realize that some people's hair can be, a very important part of who they are. But my view on that is this: you want to present a conservative image, and when it comes to hair, guess what you can do with your hair, right? You can grow your hair back. What you can't do is get back years of your life if the system takes them from you by sentencing you, convicting you, and sentencing you to state prison. You can't get those years back ever. Your hair, you can grow that back.
But I'm not saying cut your dreads necessarily. Just if they are everywhere, pull them back.
Now, this is from a man who I don't think he remembers that, but who coined the term felony hair. He's like, did you see that defendant who came in with felony hair? And by that, he meant just their hair was unkempt. Yeah. We have no problem with natural hair.
Oh, yeah.
If you look at some of our earlier videos, you will see that I wear my hair sometimes in natural styles, and I've done that in trial. We love our hair, our African-American hair. We are in no way saying anything negative about natural hair or about dreads. But what I am saying is, for the purpose of trial, you want to portray a very conservative image.
Now that could be just being neat. That's all I'm saying is keep it neat.
And let me be clear. I have never made anyone change their hairstyle, but I give them food for thought to think about how they want to present.
I mean, and what she means also by felony hair is people are brought in as witnesses and they're in custody. And that's when, and so they're not really taking care of their hair. They'll comb it in front of their face. I've seen a guy who combed his hair really in front of his face. He just didn't want to be seen. He's sitting up on the witness stand. Everybody sees him and he's looking like Cousin Ed, So, that just goes against that person's credibility. Nobody likes him. And she's right. Look, people are going to make a judgment very quickly about you. And as long as you come in and you are neat, then it's fine. You should never, or at least you don't want to be put in a position to where someone tells you to cut your hair, change your whole hairstyle when it doesn't feel right to you. Yeah, there we go. So, and sometimes like Mr. Walker, right, is just saying play the game, right? And sometimes that's the thing, is that we are playing the game. But I look at it as fit your environment. Okay, let's say we're about to go over to amusement park and stuff, and we're gonna get wet, we got to run and do all this kind of stuff. I don't want to wear my suit. Why am I running around in an amusement park with my suit on? First of all, I'm gonna draw all kinds of attention, and people will be like, "Why are you running around with a suit on?" And it's that kind of thing you want to prevent. Someone having a reaction because you look out of place, you see, because that's not what people wear in that particular environment.
Well, Lawman, unfortunately, we are again.
No, we're not.
We are.
We got 2 minutes.
I'm
sorry. We started a little late.
So
okay.
Actually, we only have about 4 minutes left, and there are a few
Let's
things
get some questions.
That I wanted to discuss. I got some things from viewers.
Yes.
That they had sent in.
So here's the thing. Next time, we're going to take it up from where we are, which is this jury selection process and your role in it, because you actually play a big role in selecting your jury. And there's some things that you should do as a defendant that your lawyer may not tell you, but you should do to make sure that the jurors see you and understand who you are. You have an opportunity in the very beginning, while she's getting ready, you have an opportunity in the very beginning to introduce yourself to that jury, and you should take advantage of that.
So we had one of our viewers send us, and I think I sent those to you, and a couple of recorded incidents. One where the officers entered the home and arrested a man because his front door was apparently open, and the The officers entered and said that they were just checking because they saw the front door open and thought there might be something wrong. And the man indicated to them, there is nothing wrong. You had to not only walk through my front door, but I think there were
Up
2 or
some
3
stairs.
other doors that they had to walk through to get to the area where he was located. And what he told the officer at that point is, you can now step outside of my home, and then I will continue any conversation with you outside of my home. I believe that upset the officer, who then said that he was not going to leave the home, and then that he was going to arrest the man. Now, I didn't see any additional details. It did not appear that he actually had any arrest warrant or any reason to arrest this man. So we are going to follow up on that. A second video that was sent to us was attorney catches police officers breaking the law. And that was apparently an African-American attorney who was outside of his office building, and he was throwing away some garbage. And he's standing next to his very nice car, and the officers pull up and stop him and question him about what he's doing and why he's throwing items away. And they ask for his identification, which he provides to them, but then he tells them, you are not going to run my identification because I've identified myself to you and what crime has been committed. No one has reported a crime. And the officer kind of, well, we don't know if you own this dumpster. What if other people in this area own the dumpster? So it was really kind of ridiculous, but it goes to show you that we are not immune as attorneys, African-American attorneys. We are not immune from these officers overstepping their boundaries in contacting us.
And it goes to show how they are directed towards us simply because we are who we are. I mean, you wouldn't even suspect someone in another situation in that. They're dumping their stuff. And the guy who walks in his house, I mean, the guy actually, was very calm. He seemed like he had just woke up or something like that. And the officer merely said, well, I'm not leaving now, and reached out and grabbed him. Now, these situations are happening all the time. And the problem is they are resulting in deaths or injuries, which is why in those situations, even still, am I free to leave? Am I free to go? Even the garbage can situation, when he gave them his business card, he gave them his ID. He's sitting here. His name is on the building over there. Am I free to go? And they would have said, well, we're investigating this or something like that.
Oh, well, they did say, but there was nothing to investigate. We have a few comments here. I hate it, but choosing your battles and acknowledging the reality that we go up against is very serious.
That's true. And I understand, sometimes we can't be who we are in a certain situation, but we have to be what they may think we are.
There's also an additional comment from Sean. Therapy should be offered to jurors on cases that are severely violent. I'm sure there's some type of PTSD. That I would actually disagree with. I don't think actually just hearing about the impact of a crime is going to cause PTSD to someone. And if it does, that person probably should not sit on that type of jury. And you will get that option. I mean, the court will say, if it is a child molest case, if it is a murder case, if it is a case that the juror feels they cannot be fair on, they need to state that, that no, this kind of case I can't do. I'd be better off on a DUI trial, right?
Or a theft case, something like that, where there is no violence whatsoever.
And
that's something that's taken care of in voir dire. That is something that, if it's going to be that kind of case, your lawyer has to be cognizant enough to go, you're going to see some pictures of really, really gross stuff. You're going to see, or you're going to hear about a sexual activity, that was brutal or something. And
it's not just the lawyer. We have to rely to a certain extent on the juror, on the juror being honest in answering the question. Not just saying I can be fair because they don't want to be seen as someone who might be viewed as being unfair, but to really state that if this is not a case for you, then you should not sit on sit on that jury.
And the skill of your lawyer actually will bring that out. You really got to press some people sometimes. I've had many Moles case where people can talk about the issues that they have in private, and the judge can take that person in private. And then you learn they're over here releasing information that they never talked to anybody about in front.
Yes, and there are times when it seems to me sometimes that they kind of discourage people from discussing everything in private, because that can make the process go longer, because that person, if it's in private, needs to be spoken to without the other jurors present. Yes. So yes, jurors do need to know that they can indicate that they want to discuss something privately. That way they don't have to reveal something about themselves or about how they feel in front of a room full of strangers.
And I'm sure me and Carm can tell you many different situations. I got 1,000 of them where you being, one, wow, this has that happened? Okay.
But if they hadn't been allowed to discuss it in private, they would have just said, I can be fair and continue to sit on that jury. And we don't want that. We do need to wrap it up, but I did want to mention one other factor, one other, I guess, piece of information that has happened this last week, and that is that Cornel West resigned from his position at Harvard University in an open letter.
Yeah.
And I believe they denied him tenure again.
Oh, yeah.
And that is the reason for that.
And I'm kind of glad he did that, It's one of those things where he was there, he felt he earned that spot with them, and he brought them a lot of notoriety and things. And that's what you want from your professors. But yet, just like the other black woman who was denied the tenure too, right around the same time, it just seemed like, is this a backlash? Because he will speak out. So we need to silence him from Harvard University. So,
now Harvard will say, oh, no, we're not silencing him. He didn't meet our standards for tenure. But if Cornel West does not meet your standards for tenure, I don't know who does.
Guess I won't be speaking at Harvard soon.
We do have one other comment that says, since the world is becoming more AI friendly, do you ever think that a jury could become less human driven? Who knows in this world?
Well,
I don't know about in our time.
I'll tell you this. I find that people are far more withdrawn. They don't want to say anything. And they'll sit there quietly and just, wait for something to happen. And I think it's because of the lack.
I think what she's asking is whether or not we think that the jury, being a juror, could be taken over by basically machines rather than human beings.
No,
and
never.
I would hope not.
Yeah,
I would hope not, because we know that there are all sort of algorithms that are against work against certain individuals. So we hope not, but who's to know what will happen in the future? One other comment from Sid Williams: the whole system is rigged. If this isn't motivation to go back to school, to be one of you guys. Well, we certainly appreciate that. We have reached the end of another episode of
They happen so quick
with Lawman and
Carmen B.
All right.
Now, we're going to pick up where we left off before, So we're in the middle of picking a jury for trial. And I'll tell you something.
We'll pick that up next Friday.
Well, and we shall, but just to illustrate, look how much is going on. And we were just talking about jury selection. So there is so much to a trial. That's why when that comment earlier about should they have a day prep and stuff about what happens? Oh, yes. And you should educate yourself. A person can come down and watch a trial because there are public events. And if you have the opportunity, you should do
Pre-pandemic.
All right. Now, all right. But they're going to open up these courtrooms.
At some point. We'll see. Not right now, but at some point, hopefully it will go back to that.
It would be good to watch it because you actually will see these things in operation. And it's good to sit there and watch how people react to things. I consider myself a jury. I love picking a jury because it gives me a chance to communicate straight up with people. All right. I know we got to go, Carm. We got to go. Thank you, guys. Enjoy your evening. Please be good to each other.
Yes. And we appreciate your viewership.
Hang out with Courtside again, please.
Next Friday.
That's
6 p.m.
We'll be here.